Hello and welcome back. We've received the decision from the Court of Appeal about our interrelated applications, which were designed to bring to the fore the covert harassment my family has been suffering from at the hands of influential doctors, skeptics and humanists, along with the staggering misrepresentation of the evidence which has led to judgments far removed from the facts and actual reality. It likely won't surprise anyone who's followed this story that our applications have been refused. But not because the facts weren't on our side. No, there's something else at play here. So let's take a look in detail at the reasons why Lady Justice Sharp judged that our applications were totally without merit. This analysis will be done in three parts. The first will focus on her decision about our application to reinstate the harassment claims. The second will look at how she dealt with our application to reopen the appeal on defamation. And the last one will offer my concluding thoughts. So let's get started. Sharp states that our application to reinstate the harassment claims against Melanie Bing and Andy Lewis of the Quackometer was a hopeless attempt on vexatious grounds to challenge an unimpeachable case management decision made by the judge. Only those who have to deny facts and evidence would rule that sticking to facts and evidence is being vexatious. Not a good start for impartiality. She gives her reasons thus. The application before the judge was made extremely late. It would have led the vacation of the trial date, which was imminent, and, as the judge found, it would have vastly widened the scope of the proceedings, with the consequent implications for court resources and costs. That is indeed what Llewellyn said at the time, and that's despite him seeing a number of obvious candidates of Lewis and Bing covertly inciting organizations and individuals to shun the claimants by portraying them as dangerous and mentally unstable. His words. In fact, there was so much evidence of this course of conduct that dealing with it all would have taken too long in the time that was allocated. So, for the convenience of time and cost, the application was refused. She continues. Further, the judge pointed out, to the extent the evidence was relevant to the defamation claim, it could be used without amendment. Again, Llewellyn did say that, but what Sharp conveniently ignores is the fact that he then refused to look at the evidence in court, contrary to what he had promised us. That was the basis of our application, which she conveniently sidestepped by ignoring the evidence. Evidence like this statement by Llewellyn when we were cross-examining Melanie Bing to prove malice on her part. As to whether there was deliberate collusion in setting the hounds upon you, that is not what this case is about. It is not the pleaded case. It is not what it centers on, so we need to get back to the main issues. So, despite his promise, he shut down our attempt to bring the evidence of harassment to prove malice against Bing and Lewis, and stopped us from destroying their defense. This obstruction led him to say in his final judgment that there was no evidence of them harassing us, even though he himself admitted to seeing the evidence before trial. It seems, as far as the judiciary is concerned, that just promising to do something is more than good enough, and any expectation that a judge carries through with that promise is not only vexatious, the judge's deceit is itself unimpeachable. She then moves to the evidence we had submitted for this appeal. The extract from Without Prejudice correspondence was before Simon L.J. in the first application to reopen the appeal. For the reasons given by Simon L.J., this is privileged material and in any event does not assist the applications. This is not true. Although the evidence was privileged at a time, coming out of a confidential document, it has since been mentioned in open court during the hearing for case C00SA 374 in September 2016, which means it became available in the public domain from then on, well before our first application to reopen. Simon lied then, and Sharp is lying now. As to whether it helps us or not, let's walk through the facts together. In this no longer privileged communication, Melanie Bing states that, "I want to make it clear that there has been no clinical assessment of Angel Garden's mental health by my husband. Ms. Garden is not his patient and he has never diagnosed her with any mental health issue." And this is the important bit. Any comment I have made which might suggest otherwise are untrue and understandably distressing to Ms. Garden. Now, Of course, she did make such comments to others, maliciously smearing my wife's mental health with a careless disregard for the truth. At the end of this is his, that's her husband, Professor Richard Bing's, clinical judgment, which she seems to have forgotten. Or, Angel has a borderline personality disorder. This is a clinical judgment, not a personal opinion. In his decision to deny us our first permission to reopen our appeal, Simon ruled that the evidence given by Melanie Bing was consistent with the content of the letter. That argument, by the way, was put forward by Price of Doughty Street Chambers. Simon agreed with that non sequitur and ruled that any comment I have made which might suggest my husband had made a clinical judgment of Miss Garden are untrue and understandably distressing to Miss Garden, was the same as her saying under oath, "If what you are saying is that I am pretending that Richard has made a diagnosis of Miss Garden, it is completely untrue." Simon's lie is so blatant and obvious, and yet Sharp just doubled down on this highly damaging misrepresentation of the facts to protect malicious harassers. Finally, she looks at the video evidence we had submitted, and she states that the applicant's video footage appears to be a different camera angle of footage disclosed at trial. It adds nothing to the merits and was available at the time of the trial. That is again a lie. The new video footage extended beyond the original clip and included serious slander by Andy Lewis, who tried to portray my wife and I as a danger to children to a group of people. Not only that, but contrary to her statement, this extended footage and obvious slander was not available at trial, which is exactly what we had raised it in this application. So many lies and misrepresentations by Sharp in a single paragraph, to manufacture the erroneous conclusion that our harassment claims were totally without merit. How does she deal with the defamation claims? Well, check part 2 to find out. Thank you for watching. Don't forget to like and subscribe, and I'll see you next time.